All right. Thank you very much for joining us today. As we were experimenting with earlier, this workshop will actually be interpreted in a couple of different languages. So if you're interested in Spanish, Vietnamese, or Mandarin, there's a little world at the bottom right of your screen that you can click on in order to be able to view and listen to the presentation in one of those languages. All right. Today we're going to be talking about what kinds of things you can do to prepare for the end of the commercial eviction moratorium. And we have an announcement associated with that, which we'll also get to. Right now, just in terms of practicalities, we are going to be recording this webinar. The objective behind this is to make it possible for people who are not able to attend today to be able to benefit from the information that's included in this and the good ideas that you'll be hearing about. We're also, as I mentioned earlier, pleased to offer this webinar in simultaneous interpretation into Spanish, Vietnamese, and Mandarin. Again, you'll go to the lower right-hand corner, click on the little world, and be able to choose your language of preference. We're going to use the question and answer function in this presentation. So you'll be able to go to the bottom there. If you have questions during the presentation, click there. They'll be recorded. In the event that it's fairly specific, the presenters may choose to answer it at that moment. Otherwise, we'll answer the questions at the end of the presentation. We've allowed about 20 minutes for that. We'll also use the chat function in order to make announcements. So keep an eye on that. If something comes up, it's likely to be a link, something else that may not be all that easy to see. The other thing that we're going to ask you to do is after the event is over, if you could follow the survey, it would be great to get your feedback about the kinds of things that you would like to see us do differently, or the things that you loved that we should repeat again. So hopefully you'll take the time at the end to do that. My name is Des Woodworth. I'm an Economic Development Officer with the City of San Jose. I have the pleasure of working with about 30 small business assistance organizations under the rubric of businessownerspace.com. It's a great collaborative full of really inventive and supportive organizations which are prepared to help you with this and other kinds of issues that you may be facing. And I've invited 2 organizations to join us today because they have the right skill set. There are other groups, as I said, there are more than 30, and I'd be happy to introduce those to you as well if you want to contact me at the contact information here. This webinar is part of a series that the city is putting on. The next one will actually be on this coming Monday, and we'll cover the round 5 of the California Relief Grant Program, which provides grants of between $5,000 and $25,000. So definitely of interest to many people. You can get additional information at the link that I've provided here, which will actually connect you up with the other types of webinars that are often, including recordings of previous events that we've been doing. Today's panelists are Mel Weisblatt from SCORE. He'll be introducing himself and providing additional information about SCORE. Gray Torrico is with Start Small, Think Big. She's actually arranged for 2 representatives, Cooley, to come and talk with you today about the legal aspects. And Start Small, Think Big does legal assistance, but also is able to connect you up with a variety of other assistance. And she'll be discussing that in more detail to let you know about the resources. Said earlier that we had a bit of an announcement to make, which is that the county has, as of this morning, very early this morning, distributed information indicating that the Board of Supervisors in Santa Clara County will consider an extension on March 23rd to the existing eviction moratorium. So that's good news in that it's likely, although not guaranteed, that they will move forward with that, which will provide anybody who's been putting off the decision about how to deal with the eviction moratorium a little bit more time to be able to get their arms around that. And as I mentioned, the panelists today will be able to provide you with concrete things that you can take and put to good use. Currently, the moratorium is set to expire on April 30th. For those of you who've been paying attention, earlier it had been March 31st. but the governor's action to extend the eviction moratorium included something which moved it to April 30th. And so there is there's already an extension beyond what you may have had, but the county will also be looking at potentially extending that to the point where it would end potentially in June 30th of 2021, or perhaps as late as August 15th, 2020. A little bit more time associated with that. The other pieces of the moratorium are that you'll have 6 months from the actual expiration in order to pay half of your back rent, and you'll need to pay the rest of it within 12 months in order to be in compliance with the program. So you may have been choosing not to address this earlier, but we're reaching the point where it really is important for you to tackle this. Any negotiations that you enter into now can lead into long-term benefits in terms of the reductions in the costs that you have to pay legally because you have some kind of contract with the landlord. So I encourage you to listen carefully and to leverage the resources that are available to you. With that, I'm going to invite Mel to share his screen so that he is able to pull up the appropriate information for you to see. While he's doing that, I'm going to remind those who are interested that we are providing simultaneous interpretation. If you click the little world at the lower right-hand corner, you can select a language other than English, including Vietnamese, Spanish, and Mandarin. Mel, thank you so much for being here.
Just want to make sure, can you see my screen up?
We can, yes.
Good, okay. So as Des said, my name is Mel Weisblatt. I am one of the volunteers with Silicon Valley SCORE, and I'll give you the whole advertisement for it at the end. But also prior to doing that, I have been a business broker in the area for 32 years, dealt with a lot of landlords, a lot of tenants, a lot of leases. So I want to go through and talk a little bit about, as a tenant, and we're all in difficult times, what is it that you can do? Why doesn't this click down?
You may be able to use the page down.
I try. Oh, there we go. Now I got it. Okay. So the first question is, and it does have a lot of difference, what kind of space do you rent? Are you retail space? And I differentiate retail from restaurant because of its particular needs, office space, manufacturing space, or R&D space. And the reason is there will be differing needs for each of those and differing requirements for each of those spaces to be functioning after hopefully this whole thing ends. So we'll talk a little bit about that as we go on. So you also need to look at what is the current status of your lease. And I know Rachel will talk a little bit about this when we get into the legal aspects, but I'm not going to get into the legal part. But look at your lease now, and how many years does it have to run? Is it a long period, like you're in the first year of a 5-year lease? Is there an option period with the lease? Or is it expired or maybe soon to be expired? Or is it a month to month? Now, each of those gives you some options to work with your landlord so that it can be a good and positive situation as you go through with the landlord on it. So when you look at this, one of the things you need to do is to decide what your space requirements are going to be in the coming year. And we've seen this happening a lot, of course. Of the 5 kinds of spaces, they can be very different. If you're in office space, you may decide you can downsize or do without it altogether because some of these things are happening. So this is what you have to talk with your landlord about. If you're in an office space, one of the ways you can cut back is by asking your landlord, hey, look, this is really hard for me now. There's a space down the hall that's half the size, and can we make some arrangements even though I have a lease to move into that space? Or like I say, or can you do without the space altogether, in which case you're going to be looking at what to do to get out of the lease. And Rachel will be talking a little more about that too, but there are some options in there. For restaurant space, can't really change it much because the move would be horrendous, the cost of the move, and the location is extremely important. If you're in a retail space, the location is extremely important, but it could be very nearby, for example, in the same strip shopping center or the same block, and it wouldn't be too bad to move there and wouldn't have much of a loss of customers. Manufacturing and R&D, of course, location is not so important, but the cost of the move can be very important, the middle one. Restaurants and manufacturing, particularly, a cost to move to smaller space or just a different space could be prohibitive. So these are the things that you need to think about as you're looking at your space going forward. What can you reasonably do to either keep it or change it? Next important thing is, and the first word is the most important, talk to your landlord or management company. Too many people try to say, if I don't say anything, maybe it'll go away. Well, your landlord, and when I say landlord, management company, same thing, needs to know about your business and what's been happening over the past year. Bring financial statements with you, showing what you did in 2019 and then 2020. Show what's happened, that you've been trying to make this business go, but it's just unreasonably difficult for it to go. And one of the things to look at is say, but when we open up, here's my business plan, and have a solid business plan. So here's when I put in the big plug for SCORE, and I'll talk more about it at the end. We can help a great deal with that business plan. We've been working now with quite a few people who are looking to reopen and have to really work their idea about how they're going to do it. At the same time, you have to be aware that your landlord has expenses as well. That's not just he's grabbing your money from you, but the bank hasn't relieved him of his mortgage payments, taxes, insurance, and upkeep. So this is where some of the negotiations have to come in as to how do you, work with the landlord and make sure they understand that you understand that they have expenses to deal with as well. So again, before you begin, you should go in prepared as much as possible. You have to think about your options with your lease situation and your space needs going forward. If your lease is coming up to end, it could be very easy to talk about going to a smaller space. And even if it's not, I think most landlords will look very favorably upon keeping you as a tenant, even if you're going to a smaller space and have the larger space available. May also depend, I got a couple of typos in there, I'm sorry, on your legal situation. And Rachel will be talking about this in more detail. Keep in mind, you do have a legal contract, but keep in mind your landlord is also a person who understands the situation of what's going on. And it could depend on your financial situation. If you're beginning to turn the clock forward and turn the corner and find that you're now beginning to have more income and hopefully profitability in your business, so you can start paying back some of this money. As I said, make sure your landlord knows that you understand his or her financial needs. And when you do that, discuss with the landlord how you can help them meet the needs. Can you pay 25%, 50%, $10 a week? I don't know, whatever it may be, but something that will help the landlord to pay his bills as well. And so within this context, come up with some suggestions. And this is what you should be doing ahead of time, is coming up with some suggestions and ideas of the way that these two needs, your need to find money to pay, landlords need to find money to pay their expenses, can come together. And the most important thing is ask for help from the landlord. Never threaten by saying, if you can't do it, I'm just going to move out, sue me. That's what'll happen. People like to respond when you ask for help. People are good people generally. And I found that, whenever I worked with negotiations, with selling businesses, if there were problems with say the buyer not having enough cash, and they would say to the seller, what can you do to help me? I know you want to get together on this. I know we want to make it work. How can you possibly help? Okay, so you need to suggest some ideas for long-term repayment of your back rent without overburdening your business. Now, I know Des went through some possible dates coming up that could go to mid-2022, the end of 2022. But if you have suggestions by saying, as soon as I get going and as soon as my monthly income, gross sales goes up to this amount, I can pay you this, and I'll be doing more as it goes more. And, tell the landlord, hey, anytime I'll give you my monthly financial statement so you can see what I'm doing. And trying to convince the landlord that you can't overburden your business with the rent or it's sure to go under. And then suggest a repayment of a portion on the back rent only before going too much forward on the new rent. All of these things will help you and the landlord kind of mesh together and to work together in this. And certainly the landlord would love to get you back to full rent, as I'm sure you would too, because that means you're making money. So suggesting ideas of easing back into full rent, so as, again, not to overburden the business, but to show that you're willing to work and get this paid off. Okay, so can you downsize? If it's an office space, probably. Moving costs, as I said, should be low. If it's a real retail space, you can probably move to a smaller space in the same shopping center without losing customers. If it's R&D or manufacturing, and if it can be moved, you have to assess the cost of the move based upon the savings of the rent and how long it takes you to catch up to that. Worst case, and got to bring it up because you got to say it, business has no choice but to close. But you have 4 years left on your lease and you've personally signed for it. Now, again, Rachel will talk to you a little more about this, but I found a lot of times you can negotiate a buyout on the lease and by paying a certain month's worth of rent and then being forgiven for the rest. If the lease is almost ready to expire, sometimes you can just pay out the last 2 or 3 months and your obligation is gone. If you're in the case of a month-to-month lease, that's exactly what it is. There's no obligation on your part or the landlord's part. So successful negotiations are always win-win. I learned this a long time ago. Try to learn the landlord's wants and needs. Know what your wants and needs are. Wants and needs are defined as those items that are solid beyond which the party cannot go. One of your needs is, I can only pay $2,000 a month rent until I get more income. That's the bottom. The landlord's needs are, I have to pay X number of dollars in mortgage and taxes a month, and I've run out of money. That's his bottom. Wants are those items that either party would really like, but they are negotiable. So The idea is to meet the needs if at all possible, and then you're in a position to negotiate the wants. And this usually turns out to be a successful negotiation. So now I give my pitch for SCORE. SCORE is a nonprofit resource partner of the Small Business Administration and was created by an act of Congress 57 years ago. So we've been around for a while. By the way, the term SCORE originally was an acronym that meant Service Corps of Retired Executives. A lot of people aren't retired. Most of us were never executives, so now the word is just SCORE. These are the things that SCORE does. We do one-on-one mentoring, both now in person and well, not in person yet. We haven't gotten back to it, but online. We have workshops, seminars, and various events. In San Jose, we do a lot of workshops through the public library. We have a whole set of business tools and templates, including business plans and a lot of other things if you go to the SCORE website at score.org. We do provide free and confidential mentoring, and you come back as many times as you need. I've been working with some clients for years, and frankly, I'm like their board of directors. Now, Silicon Valley SCORE, who are we? We're, again, an all-volunteer organization. We have about 70 volunteers who do various things. Some are just teaching, some are involved in one-on-one mentoring, some do administrative work. And we're there for you whether you're just beginning to start your business or have been in business for many years. And just like the National SCORE resources, we offer mentoring services, classes, and we have a huge library of resources. And we've put together a complete, well, shouldn't say complete, but a huge list of about 300 different websites that can help you in the various categories. This is our website, siliconvalley.score.org, and that'll get you in if you want to have a counseling session. And that's my pitch. So I'm going to stop the share.
Wonderful.
Turn it over to Des.
Wonderful, Mel. Great, and I encourage any of those of you who saw the benefit in that to connect up with SCORE for additional details on ways that they can be of help to you both during the current situation and in an ongoing way. Next, I'm going to ask Gray to talk about Start Small, Think Big, and then ask her to introduce the guest that she's arranged for as well.
Sure. Hopefully everybody can see my screen. Thank you so much for having me. I'm excited to be here. Excited to be in community with everybody related to ways that we can be of support to you and your business. I'm going to speak slower than I normally do just to make sure that our interpreters are catching up. I know it's a lot to have to be on the mic and simultaneously interpret, so kudos to them for being here. As Des said, I am Gray Tarico. I am the Community Engagement Manager for Start Small, Think Big. I'm based in our San Jose office, so in San Jose, obviously, but we have different offices across the United States. So a little bit more about us. We are a nonprofit. We started about almost 11 years ago out of New York. Really wanting to connect small business owners to quality and free services, particularly wanting to connect them to legal, marketing, and financial support. We traditionally have worked and continue to support under-resourced small business owners specific to Black, Indigenous, people of color. So excited to hopefully support anybody here who needs the help, especially during this time. Again, we are headquartered in New York, but we have physical presence in both Oakland and San Jose. And due to the pandemic, we are working virtually. So if you do reach out to us, again, feel free. We do have staff geographically placed to support you and your needs. So I'll just continue here. So what do we do? I'll talk a little bit about the legal component because I think it is one of the ways that we are showing up for our community members, specifically business owners, and one of the ways that we've been connected to the city of San Jose and excited to have, representatives and attorneys from Cooley, who are one of our huge firm partners currently. So we basically connect small business owners with volunteer attorneys and connect them to specific things that a small business owner may want to complete. So for example, if currently you are needing lease review, we have the capability of connecting you to pro bono volunteer attorney support to make sure that you get that lease reviewed. And in the future, you also understand, what are ways that you can, again, understand your lease and understand the ways that you can negotiate with your landlord. Again, hopefully getting us through this pandemic, but also looking to the future, ways that you can also protect yourself. There are other components, of course, to our work, but legal tends to be one of the ways that we are assisting, especially during this time. So, of course, there may be other questions. Feel free to email me at the end of the presentation. I share my information with you. Quickly on client eligibility. So we have two different components that we're looking at when we're looking at who can actually access our services. So if you do want to become a client, these are the two components that are most important to us. We're looking at eligible businesses that are actually currently selling goods and services in the last 3 months. Now there's a caveat, right? There's obviously a pandemic, so many businesses may not qualify under the current sales component. However, what we would look at as sales pre-pandemic, so pre-March 2020, you were open and you did have sales of $500 or more, then you would most likely qualify under this particular requirement. So I wouldn't really, read too much into this. We definitely have ways to be flexible here and ways that we can support business owners to get onboarded for our services. We also look at financial income. So this is a household income based on 500% of the federal poverty guidelines. So this is something that once you apply, you will have the ability to see exactly what we're looking at. So looking at your household size juxtaposed to your household income is something that we would look like, and is also something on the actual application. So again, there may be more here to say, but definitely feel free to reach out if this is unclear. Really quickly, we have the rapid response program, which is another way that we are supporting business owners. You don't have to become a client to actually get support from the rapid response program. This is free to all business owners who have specific need related to pandemic issues. So for example, you have questions related to lease issues, you can definitely get support from us by virtue of, for example, us connecting you to firms like Cooley that do great work in making sure that clients get one-on-one consultations for free. Rachel and David are some of the teams that we have worked with in the past, and we definitely are excited to continue working with them in the future. This is just a full slate of information. I will definitely chat over our information that's most relevant, including our application, but you can definitely find this online at our website, www.startsmallthinkbig.org. And finally, my information personally. So if you do want to reach out to me, you can definitely do so at that email address, and I'm happy to figure out the ways that we can support you. So with that said, I'm going to go ahead and pass the mic over to Rachel and David really quickly. Rachel and I have done this before. We've done many webinars together, so I'm always grateful for her presence here. Rachel is part of Cooley, one of our big firm partners locally. She focuses her practice on all stages of real estate transaction. She also has been doing a lot of one-on-one consultations with the Rapid Response Program. She does a ton of workshops like these. So we're excited to have her. David Crawford is a senior associate with Cooley as well. Like Rachel, works as part of the real estate team, working with corporate and individual clients on a broad spectrum of different transactions, including leasing, purchasing, sales, but also, again, really deeply invested in wanting to support community members, especially small business owners during this time. So without further ado, I'm happy to pass over the mic to Rachel and David to take it from here.
Thank you so much, Gray. Just want to confirm that you guys can see my screen. Okay, and it's the right screen. Perfect. Thank you. So as Gray mentioned, David and I are real estate attorneys at Cooley LLP, and we work on a broad, a lot of real estate matters, including leasing. I'd say that from last year, around March, once the pandemic hit, we've had so many questions from clients, our tenant clients, about what's next, what should we do, where should we go from here. So we're always really excited to do these type of presentations and just share the knowledge and other advice that we've been given to our clients. I know a lot of the stuff that I have in my presentation, some of it, not a lot, but some of it has already been covered by Mel. So I'll try not to repeat things unless it's absolutely necessary. But I did want to start with an overview, an introduction of COVID-19 and the type of impact it has had on tenants and our clients. You know, last year, COVID-19 hit, and from that, it has resulted in a lot of shelter-in-place orders, which have impacted small businesses. Specifically, these shelter-in-place orders have restricted small businesses from using their leases, their spaces, and it's also there are also orders, specifically the moratoriums, that have kind of provided some type of protection for these small businesses, but we'll talk more about that and the restrictions on those protections as well. Whenever a client comes into us and talk to us about, you know, we've been impacted, what should we do? The very first thing we tell our clients is to look at the lease. The unfortunate thing about leases is that a lot of our clients tend to think it's just boilerplate language. And so they see a lease, they sign it, they've never reviewed it, they don't know anything about it. And then we get the lease and we have to go through and say, well, hey, it's not boilerplate. It's really important to make sure you go through the lease prior to signing. And that might be a bit late at this time. But, you know, moving forward, be really careful about what you sign. And just to mention, this market is pretty good for small businesses. So for those of you who may be at that stage of renewing your leases or looking for new space, this is the time that you look for those things that are really important and try to present them to your landlord so that you can have more favorable terms moving forward. It's really critical. But back to the reviewing the lease, there are two things that are really important that have been helping tenants during this time, and that's language on lease terminations and also language on rent abatement. Unfortunately, there's not usually favorable language there, but to the extent that there is, it's usually very helpful for tenants in trying to get out of these type of the impact of COVID-19 and the resulting orders. Many leases have a provision whereby the landlord will abate rent under certain circumstances. And this particular provision is really important because when the provision is very broad, it supports and helps our clients. For example, I know the first one might be a bit cloudy, but the second clip is a copy of, you know, some language from a lease. And what it says here is that in the event of any material interference with tenants' access to or from use of the premises, which lasts for over a period of time, that rent will be abated. And the term material of interference here is so broad that we've actually been able to use this provision to help one of our tenants get out of a lease. I mean, we use this to help terminate the lease, but even without the termination, the material interference could include a government order, right? It's such a broad term. It wasn't a defined term. and we use this to push back on the landlord. This is not always typical in leases, but that's why it's so important to review the lease, because the tenant had no idea that this language was in there. We were able to help them draft something to the landlord, presenting, this particular provision, and we were able to get, good negotiations from there. So it's really important. Force majeure is probably the one provision or the one part of the lease that tenants try to just use. And we have to be really, really careful with force majeure language. Force majeure clauses have the potential to provide some type of relief, but oftentimes when force majeure is in the lease, there is a carve out, right? A specific carve out that removes the obligation to pay rent. So what you'll see in a lease is something like, the parties are relieved from whatever obligations that they have, with the exception of the obligation to pay rent on the part of the tenant. So even though there is force majeure language, and it's really, tenants, some of our tenants are sophisticated. Some of them know the term force majeure, and they see it and they're always excited, like, this is an act of God, or this is an unforeseen event. Yeah, that's true. But most leases will carve out that obligation to pay rent, which means that it's really not very helpful. Another very important thing with respect to leases is the personal guarantee. And lots of our clients have been really scared. They've had so much anxiety over this having guarantees as part of the lease, because what it really says is that, although the moratoriums may provide some type of protection, the guarantee is a type of recourse that the landlords can use for any type of default under the lease. And so to the extent that there is a guarantee, you need to be careful with that. And when you're also talking to your landlord with respect to requesting an abatement or requesting a termination, if there is a guarantee, as part of the lease, you need to make sure that any type of relief includes that, right? So for example, if the landlord says, okay, I'll give you a rent abatement for 3 months, we need to make sure that in this amendment or agreement, it includes that the landlord would not go after the guarantee because they've provided you with this abatement, right? So the two work hand in hand, and you want to be really careful with that as well. Co-working agreements, if your tenancy is part of a co-working agreement, we've had more favorable results with respect to this, simply because we've been viewing these more as licenses and not leases. And so it's set up like a license where the landlord is providing a service. The service is access to office space, access to conference rooms. Some of them include coffee and other really nice amenities. And so what the moratoriums and the government orders, in particular, the shelter-in-place orders, have been doing is restricting the use of office space or restricting the use of non-essential services. And if there's a co-working agreement where the service provider, such as WeWork and Knotel, there are quite a few of them, are providing a space, but the order restricts them from doing so, then we can have the argument that rent should be abated because the service cannot be provided. So we've been having some stronger arguments there, but as I'll discuss a bit later, lots of this is in litigation right now. So we're just waiting to see the results of some of those cases to see how they would be applied. But those are the type of arguments we've been trying to use to help clients. Subleasing an assignment is extremely important. I know a lot of our tenants, they're tenants. They don't want to be a sub-landlord. They don't want to take on the role of a landlord. And so sometimes they're quite discouraged at the idea of potentially subleasing their space, and sometimes they don't even consider it, right? But most leases would provide for or would allow the tenant to assign or sublease the space with landlord's consent. And the reason this is an important exit strategy is because if you're in negotiations with your landlord, and the landlord, for example, presents to you a termination fee that is extremely high, something that is not that you can't afford or that the business cannot take on at this time, your best option might be to sublease or to sublease the space to the extent that you can find a subtenant who's willing to take the space. The challenge here is that subleasing the space in this market is not the greatest. And so you have to be mindful of the type of, the pricing or how much you want to list the space for. I was talking to a client just yesterday who, they've been going back and forth with the landlord to try to sublease the space, or actually to try to terminate the agreement. They couldn't agree on a good termination fee. And so they decided, okay, let's just sublease the space. And they actually got a broker to help them, and they advertised the space for more than they were even paying. And because they thought, well, we got it at a really good price, so why not try to see if we can make back some money here? And I'm like, no, not in this market. And actually, it's more beneficial for you to rent it at a 10% or 20% discount, try to attract a lot of offers, and then you would probably notice that that 10% or 20% discount is much cheaper than the termination fee that you don't want to pay. So these are some things to think about. I understand lots of tenants don't want to take on that responsibility, and also if you sublease the space, your obligations don't go away. The landlord can still come after you. If the subtenant breaches or is in default. But this is another option, another exit strategy you can use if you're not able to work out a good termination fee with the landlord. As noted here, it's very, very rare that we will see a termination right in a lease. It's almost never there. But if you have one, good for you, but it's very rare. And so getting a lease termination is something that you would have to negotiate with the landlord. So far, we've been seeing anywhere between 6 months to a few years. I think what it really comes down to with respect to lease terminations is how much time is left under the lease, the amount of rent that you pay, the amount of tenant improvements the landlord would have initially put into the building or the premises. There's a lot that goes into that, but to the extent that there's no termination right, which is likely, is something you have to negotiate with the landlord. Frustration of purpose, impossibility, these are legal doctrines and common law doctrines that are going to be litigated, and actually some of them are being litigated right now, and sometimes their clients want to use them, like, this is frustration of purpose, it's impossible to perform, and these type of foreseeability type arguments. But what makes these arguments challenging is that they have to be litigated. And what makes litigation challenging is that it's expensive. And so if you're really having a tough time because of the impact of government orders on your particular business, you probably don't want to spend your money in this way. The deeper pocket tenants these are the ones who are actually litigating and just going all the way. We've seen some major law firms do it. We've seen Victoria's Secrets do it, but this is not something we would encourage for really small businesses who are trying to preserve their finances and ultimately their business. Insurance. So many leases, all leases have some type of insurance requirement, or if it's well negotiated, it should. Some of them have business interruption. So while insurance is required, not all of them have business interruption insurance. So you have to read that section and see if it applies to the lease. Unfortunately, insurance companies have been pushing back on this argument, claiming that, business interruption is only relevant to physical damage. And so that because there's no physical damage, there should be no claim. This too will be litigated. We've seen it, we're hearing about it, nothing to report right now, but the most important thing we've been telling our clients is, make a claim and reserve your rights, because if these cases are favorable to tenants, then we don't want anyone to say, well, we didn't make a claim. One of the most important things in civil litigation in general is timing. Like, timing is very important. So we always encourage tenants to put the claim in, reserve your rights so that it won't be too late at a later date. For those of you who may be considering new leases or renewals where you can allow for changes, you should talk to your insurance provider, and if business interruption is something that's important to you, you should add it, right? It might come at a higher premium, but we've seen the advantages of having business interruption insurance during a time like this, where for several months some companies have just been closed. We've spoken a little bit. I think Des has provided an overview of the moratorium, so we wouldn't get too deep into it. But two things that I really want to highlight with respect to how moratoriums work in general is to be very careful to check the moratorium in both the city and county where your business is located. We have city level ordinances, we have county level orders, we have statewide, and sometimes people are confused as to which one, but you need to look at these, and you're trying to apply the one that's most protective, right? So the one that is most protective is the one you want to follow. And I wouldn't say there are contradictions between the three levels, but sometimes others provide for more protections than others, and you want to be very much aware of that. The second important thing is making sure you're looking at the right moratorium with respect to your city, right? So we have tons of tenants who live in Oakland, which is Alameda County, but they operate a business in San Jose. And so they're applying, or they're talking about moratoriums. And I'm like, no, that doesn't apply. Like, what you really should be focused on is the moratorium in the city where your business is located, or the county, as the same may be applicable. What's also important there is looking at the right moratorium with respect to business, commercial moratoriums, and also just rent for private residences. And sometimes the moratorium has both protections for rent and also for commercial and also for your apartment, but it's not always the same. And again, recently I had a client who was trying to pay 50% of her rent starting as of January 1st, because that's what she thought the moratorium was saying, but that was only with respect to residential evictions. It had nothing to do with commercial. So be really careful that you're looking at the right one in this case. And very important that to the extent that you are looking at the right moratorium, look at the criteria. Sometimes the moratorium requires you to prove substantial loss of income. Sometimes it requires you to seek this relief from landlord affirmatively. So writing a letter, writing an email, something saying in accordance or pursuant to section 5, blah, 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 of whatever, you're not paying rent. It varies, so be very mindful of that. This is just an overview of local ordinances. Won't really go over them. There are some similarities, there are some differences, but I just wanted to have this information to the extent that the presentation is provided to you later, so you can see, what different cities are doing and how they vary. Government orders, they are some limitations. I think the most important limitation that I have to stress with clients all the time is that government orders only protect these particular moratoriums that we're seeing now are only protecting you against eviction, right? They're not protecting you against other defaults or breaches that you may have under the lease. And we saw that quite recently. As I said, we've been helping so many tenants, but there was a particular tenant that was sued by her landlord because of a breach for something that had nothing to do with the payment of rent. And because of these moratoriums, she thought, well, the courts are closed to these type of unlawful detainer cases, so I don't have anything to worry about. But sure enough, the landlord did make a claim against her for something completely different. And, you know, we knew that it was motivated by the non-payment of rent, but the reality is there are other defaults that there could be. There could be repairs, repair obligations. There are a host of several other rights and obligations that tenants have under the lease. So you have to be very careful, because some of these landlords are smart, they're sophisticated, they're tricky, and they know they may know ways to come after you outside of the non-payment of rent. So be very careful.
Right,
Rich. Yep.
Rachel, I think that's a really important point. I just want to emphasize that the eviction moratorium does not excuse you from paying rent or performing any of the other things you're supposed to perform under your lease. It only means that your landlord cannot go to a court, get an order for the sheriff to come and evict you physically. It does not mean that. So you could still be sued for the non-payment of rent. You could still be sued for not doing something else you're supposed to do. You just can't be kicked out of the space physically. So that's a really important point, Rachel, I think.
Yeah. Thank you. And then then the second thing that comes from that is that the moratoriums only last for a period of time, right? They all have an expiration date. That's very consistent with all of them. And so let's say, for example, San Jose, the moratorium expires April 30th. We expect it to be extended, but let's just say, for example, it expires then. All rent due will be paid. All rent due as of May 1st will be due to the landlord, right? It's no longer excused, because the period after the moratorium has expired is no longer a protected period. So rent will be due and payable right after that time. And there will be, most of these moratoriums provide for a delay or some type of, 6 to 12 month period that you can pay rent that was due during the moratorium period. But once it's expired, that protection is over. And so you have to really start thinking about the future as to, okay, where is the rent going to come from? Can we still afford to pay this amount, with the understanding that your business levels might not be there yet? But it's really important to know that there is an expiration date, and you have to start thinking about, okay, what after the expiration date? And I think I went ahead of myself, because that was the next slide. Tenants will be required to pay back what was due. Most moratoriums and most counties are giving you some type of grace period, which is good, but that too would expire, right? It's 6 months, it's 9 months, it's a year, and then that's it. And yeah, so once the landlords, once the moratoriums have expired, landlords would be able to commence evictions again, eviction actions again. I think one thing that's important to note here is that once things reopen, there may be a backlog in cases. And I think some tenants are trying to bank on that, like, oh, it's not going to be my turn yet. I wouldn't rely on that. The reality is that once things expire, the landlord would have that right again. So be really careful how you try to, time things and think that you can continue not paying rent simply because there's going to be a backlog of cases. And so, the landlord will take a while to get the case will take a while to be heard. One thing that is really important is that commercial leases, I should have mentioned this in the beginning, but commercial leases have very few statutory protections. What you'll find that residential leases have more. And so for that reason, it's really important to know what's in your lease. It's really important to think about these things as you continue to negotiate your leases, because once there's an issue, there's a breach, there's a default, there's something, you're looking for your lease to protect you, not some type of statutory protection that's out there. Landlord negotiations, I think Mel has gone through a lot of these. And so I think one thing I want to emphasize is really thinking about your best case scenario. So the potential future of the business, right? Does it make sense to terminate the lease? Should you renegotiate? Should you keep the space? Should you get a smaller space? And it's really important, because your best case scenario is not necessarily, it's beyond the negotiation itself, but it really looks at, what am I going to do with my business moving forward? Do I really want to stay in business? Can I afford to stay in business? Do I need a loan? How can I apply my PPP? Like, all of that comes into what may be your best case scenario. I think it's really important, and we see this so often with landlord-tenant negotiations. You have to be creative and be flexible. As I said, outside of the lease, there's not a lot of protections out there, and so you're going to be depending on your landlord a lot to be able to provide you, with whatever you're trying to get. But a tenant whose proposal is just like, I want to terminate and that's it, is probably not going to be as successful as the tenant who is willing to think about this a little bit more creatively and request some type of combination, right? Like, can I abate my rent? Can I defer the rent? Can I take a smaller space? Can I add time to my lease term, but get an abatement for a few months? Like, I can see landlords being more open to those options than someone who just says, I want to terminate. Because as Mel mentioned, landlords also, they have bills to pay. They're quite impacted by this pandemic as well. So we want to make sure that you're really careful how you present, your needs to them. Only use the eviction moratorium as a negotiating strategy. It's really good to use. You can say, well, hey, pursuant to this is my right for this period of time, but you don't have to exercise your right? If you can afford to pay rent, you don't have to not pay rent just because the moratorium says you don't have to, right? And I say that because some tenants, they want to just say, well, the moratorium says I don't have to pay rent, so that's that. And I'm like, that's not enough. Like, that's going to agitate the landlord if you're trying to wave a law in front of them saying, this says I don't have to pay, so too bad, right? Like, use it to help negotiate with the landlord, but not to frustrate them, with the understanding that they're also going through, they're having similar impacts because of the pandemic.
And also, if you can pay rent and you're not, each month that you're not paying rent, you still owe that money. So you're racking up a very large debt. So it's definitely like, if you can pay rent, you should be paying rent. Otherwise, you're essentially taking out a loan that may be hard to pay back.
Yeah. And I think it's also really important to think about your total exposure, right? So there's some tenants that say, well, I'm just going to walk away. Well, yeah, you walk away, you think about your total exposure in terms of how much rent is left under the lease, and the landlord doesn't have a duty to mitigate. Again, I said there's not a lot of statutory protections there. And so all of that rent would be due, but it's not just the rent, right? They're going to have a right for late fees, for interest charges, for all other type of expenses. So $20,000 can become $30,000 extremely quickly because of all of these other charges that the landlord can add. So be really mindful with that as well. Always try to find some middle ground, and I think Mel mentioned that already. So this last slide is just, a few examples of, what we've been seeing from landlords, and things vary from, straight up no. Most of the time, actually, when we ask the landlord for landlords for relief, they say no. I think it's almost like their initial reaction, but then you should be persistent, right? Like, the last thing the landlords want to hear in the middle of a pandemic is someone is trying to walk away, someone is not trying to pay rent. So even if the landlord's initial reaction is no, we encourage you to go back with a better offer, right? Terminations will probably always hear no. Larger institutional landlords who have deeper pockets tend to, they can generally afford more relief than mom and pop shop landlords. And we've seen more pushback from the smaller landlords that just own a little building or own, really small office space, because they can't afford it, right? They don't have a history of, like, long-term rentals where they've been, increasing their finances over time. So we've seen differences there. Landlords are really concerned with keeping long-term tenants, and so they tend to be open to rent abatement and deferral more than termination. We've spoken about that. So rent abatement and deferral, for example, is saying to the landlord, can I have 6 months of free rent, but then can I extend my lease by a year? Can I extend it by 2 years? Because having tenants occupy their space, right, is sometimes more important to the landlord than just having empty buildings with nobody. if you have if you have a renewal right, we've seen tenants do that. If you have a renewal right in your lease, you can try to exercise that right early and use that as a negotiation. Because again, because landlords are also pretty anxious about what's going on, they may be more open to allowing you to renew that right, just so that you remain in the space and they can, account for, who's there and keep the space looking busy. Many landlords are requesting term extensions in exchange for that. Like we've seen landlords present, well, I don't want to give you just an abatement unless you give me something back in return, which is adding more time to the lease. We've also seen forgiveness of operating expenses and parking fees. Even if the landlord has not offered this, this is something you can ask for, right? For those of you who are not using your space at all, you're not parking there, you're not turning the lights on, you're not using HVAC. And so, while you might not have a right not to pay operating expenses, it's pretty much of a fair act. It's a reasonable act to say to the landlord, hey, can I just, not pay that for a while since we're not using that space? Opportunity to change locations in where the premises is located in a bigger building and there is smaller office space available. So these are things that we've actually seen from landlords that they'll be willing to give. But I think it really comes down to trying not to agitate them or frustrate them and trying to find a middle ground that's, a place that's amenable to both parties. So I think that's it for us. I know we're running low on time and we want to leave a bit of time for questions. So Des, I'll throw it back over to you.
Thank you so much. Both you guys have done a fabulous job. This is a very complex issue, a lot of moving pieces, and you guys have done a great job at making it digestible, understandable, and relatable. I think you've also made the case for not deferring, not putting it off any further, because there's a lot of good reason to act now rather than wait until the issue is forced or you're caught in an awkward situation. So I want to encourage people to take advantage of the interactions that they can have with SCORE, as well as with Start Small, Think Big, because both of them are in a position to be able to help you navigate this stuff. Unlike operating your own business, probably you haven't had to negotiate a lease very often. And often you haven't been through a pandemic. I'm not sure any of us have been through a pandemic before. So there's a lot that you can benefit from by finding out what other people's thinking is. And I know that Mel and Gray have been doing a lot of thinking about this, and the folks from Cooley have clearly been doing a lot of thinking about it as well. So I want to encourage you guys to take advantage of these resources. Don't leave them on the table, so to speak. So we have about 20 minutes. Actually, I guess we got about 15 minutes. I think we've got enough time to be able to go through the questions that are available in the Q&A section. Largely, I'm going to work from the top to the bottom, but I'll do a little picking and choosing so that we get a little variety. So the first question I'm going to ask on behalf of the audience member is for Mel. What if you are closed and not able to reopen? What kinds of negotiations can you have with your landlord under those circumstances?
Well, the basic one, if you're not going to reopen, is how to get out of the lease with the lease cost. And Rachel mentioned a couple ways of subleasing. There's also just the fact of saying, I don't have it. I can pay you something. How many months rent would you want for me to get out of the lease? Because you probably more than likely did personally guarantee the lease. Very few small businesses get away without doing that. So those are the options. And even if you have to sublease your space at 10 to 20% less than you're currently paying the landlord, it may be worth those $200 or $300 a month to do it and just get out from under the big burden.
Good enough. Let me turn to the folks at Cooley and ask another question that relates to the personal guarantee. All right, we've got more questions that have been flowing in. This is good, but it is making me a little more difficult for me to find the question I was thinking before in terms of, there it is. Okay. The individual had made a personal guarantee and their lease is coming to an end in July. The inquirer has paid 35% of the rent all the way through. Now they're wondering whether or not they can work with their landlord to adjust the deposit towards the last 2 months of rent. Any thoughts on that?
To apply the deposit to the rent obligation owing, that is definitely a good tool in your toolbox.
Yeah.
The landlord has this big pot of money sitting over here that's technically yours, but you also owe the landlord a lot of money. So you can always, that's a big tool in the toolbox to say, hey, I'll let you just keep that deposit that you're already holding if you give me, something I want, for sure. The personal guarantee issue from a legal perspective is it means you personally owe the debt. And so it means that you can be sued personally. And it also means that if you wanted to discharge that debt in bankruptcy, you would need to file a personal bankruptcy and talk to a personal bankruptcy attorney. But that's a whole nother presentation.
I just wanted to continue on what David said a little bit. Certainly the lease deposit that you have can be used as a negotiating tool. And if the landlord decides to give you whatever he can do to help you along, get it in writing so it can't come back to bite you later when he says, oh, by the way, a year down the road, you still owe me for 6 months rent. Yeah, I see David nodding his head. As an attorney, absolutely get it in writing from them and discharge you from the rest of your debt.
Yeah, one thing I'll add about negotiating and the security deposit is that I think landlords get annoyed when tenants are trying to negotiate and requesting their security deposit back. It's not a good place. It's not a good place to start. Not that the money isn't valuable to you, but there's the understanding that there's just give and take and stuff like that. And so I like to encourage tenants, or I like when tenants come to me and say, I want to just relinquish the security deposit. I think it's a good starting point. More than the landlord is entitled to it anyways. Technically you haven't paid your rent. The moratoriums don't allow them to draw down on it right now, but technically that's what they would have been able to do. So a nice gesture would be, well, once things reopen, why don't you start with the security deposit, or can I terminate and relinquish it? But saying I want to terminate and give me my money back will almost for certain just like start the negotiations off on a really bad foot.
Yeah, obviously there's a lot of people involved in this. It isn't just the piece of paper. So another question comes in that the person who's asking the question said they received an email this morning saying that April rent must be paid in full with no grace period. They haven't recovered and are not able to make that full payment. Can they demand that even though the eviction moratorium is still in effect through the end of April in Santa Clara County?
Yeah, so as long as the eviction moratorium is in effect, then the landlord can't demand rent from, they can, but the tenant has a right not to pay it for that period of time. So right now, landlords should not be demanding any type of rent. And the moratoriums also have that language, right? It doesn't only speak to the tenant, it speaks to the landlords and basically says like, you can't demand from a tenant who proves. The thing about it is that you have to prove. The moratorium is just not, don't pay your rent, whatever. You have to be substantially impacted by COVID-19. And some of them require you to actually show proof of that and affirmatively request it from the landlord. So be very careful. It could be that the landlord assumes that you're not impacted, right? Some leases have rights for the landlord to demand financials upon request, you just have to share it with them. Or the landlords might just have a general sense of how your business is doing, depending on the type of business, right? They see what's going on. So, but to the extent that a tenant is substantially impacted by COVID-19 and otherwise meets all the requirements under the moratorium, they don't have to pay rent for that period of time, but they should, let the landlord know that's why they're not paying the rent.
But you
Well,
will
and
still
at
owe
the-
the rent.
Yeah,
at
but they
the
still
same
owe the
time,
rent for sure. That's
Yeah.
it's still,
You
and
know, for negotiating purposes, it would be very good if the tenant would say, I can't pay you the rent, but I can pay you 30%, 40%, whatever, to show really good faith that you're
Mhm.
trying. And
yeah,
like
and as
Rachel
David said, it's like
you
a
know-
loan, right? It's
Yeah.
like, if you don't pay it, you're gonna
Yeah.
have to pay it later, unless, some tenants have said, well, by that time I might not be in business anymore. And if you think, like that's not a good way to think of it, but some of them decide, well, I might not be in business anymore, so whatever. But as David correctly mentioned, it's still old,
it's
and so
still
you're just adding up, over, just adding up the bill higher and higher every month you don't pay.
So the next question has to do with someone who did not renew their lease at the beginning of 2020 because of the shutdown, and are now on a month-to-month lease. Will the landlord be obligated to give a new lease if the tenant chooses to stay and build the business back up again?
They're not obligated to, sorry, David, but yeah, the landlord is not obligated to. If it's month to month, which means that either party, by given the time required, 30 days, can terminate the lease or request termination of the lease. So there's no requirement there. But I do think that in this market, the landlord may prefer for that tenant to stay where they are, especially if it's a good tenant who during that time has been paying rent. If you haven't been paying rent, the landlord might just be done with you and, prefer to get someone else who might, do so. But yeah, they're not required to renew your lease, but they may want to if you're a good tenant.
So
At this time, there's not a lot of people knocking on, if you're a retail tenant, there's not a lot of other people saying, I really, really want to start a new retail business right now.
Mhm.
So you have kind of a leg up.
So in the event that someone's been occupying a space but doesn't actually have a lease, what's the legality of the rent that they owe? They haven't signed anything saying, I'm going to be paying you this amount of money. Potentially, it's all shake of the hand. What's the legal obligations under those circumstances?
So there's still a tenant. And if they've been if there's even an oral agreement to pay X amount of rent, then they're a month to month tenant. So it'd be the same as if you sign a month to month lease. So the months that you were occupying and you had some sort of agreement to pay rent, even if it was oral, you'd still owe the month that you're occupying as rent, but you're a month to month tenant. So you can leave on 30 days notice if you want.
And they can kick you out in 30 days notice.
And they
if
can
want.
kick you out on 30 days notice. Or they can terminate any agreement you had.
Yeah.
And utilities, if the utilities are handled through the property owner, then, and they're part of your lease, whose obligation is that? Or-
Still the tenants. It's part of your rent obligation. Anything you agreed to pay the landlord is part of your rent obligation.
Good enough. All right. Here's another good question. What's the point at which one should have an attorney to help with the lease negotiation or termination?
That might be a better question for Mel, maybe. What do you think? You've done it on the business side.
My point of view on leases is you should always have an attorney involved from day one. And because I don't know, I think it was Rachel or maybe you, David, that said there's so much in a lease that tenants don't understand. And I'll say the same thing. In selling businesses for 30 years, there's stuff in that I don't understand, that you need a good interpretation of what it is. Most people look at their leases and read page 1 of how much the rent is and how long it's going to last and stop. Excuse me, stop there. The fact is there's probably 20 or 30 more pages that we wouldn't used to be worried about, but all of a sudden, excuse me, it has come into play that, hey, now this could be, with abatement and and force majeure and all that thing was, oh yeah, sure, fine.
Yeah, I agree. I think from the very beginning, and I think that gray and start small, think big, that's a good time to like partner with them if you
Absolutely.
qualify. Like I always say from the LOI stage, so even before you get the lease, so we can start looking at those issues that are important to the tenant and yeah, and work from there. It's all the way through.
Yeah.
Yeah, I would just add it is important, especially because our organization doesn't deal with the litigation portion of it. So any dispute that you may have, unfortunately, we wouldn't be able to support you there. But anything before that, so, you know, getting lease reviewed, et cetera, like Rachel said, we can definitely get you connected to folks like Cooley and other firms that we work with.
Yeah, and what I found is once the tenant and the landlord agree upon the 2 or 3 major items, all those other 20 pages, there's a lot of negotiating to go on. And I've seen attorneys say, oh, we don't want this, and cross it out and cross it out, and landlords say, fine. So, yeah.
And this
From
is a
day
good
one.
time too. Like this is the first time I think in like 10 years that tenants are getting things that they don't normally get because of the market. So
Right.
definitely get your attorney to help you negotiate really favorable language.
So another question that's in here is from somebody who says that they have been attempting to that they had attempted to renegotiate their lease, but their landlord basically changed them to month and increased their rent by 40%. And then over the last year, they have been unable to contact the property owner, and they're wondering what it is that they should do.
I think call for help. Call start small, think big for help in that one.
Yeah,
The
yeah.
particular circumstance, and get connected with the rapid response team, because that's probably a little more complicated than at least I could answer in 30 seconds.
Yeah.
Yes.
Yeah, 40%. That yeah, there's some strange facts there we will need to dig into.
Yeah.
All right, good enough. Let's see. So one of the questions has to do with the the end of the commercial lease moratorium, commercial eviction moratorium in Santa Clara. The county website says March 31st. But April 30th is listed. Rachel, do you want to answer that, or shall I?
You could. I mean, you and I spoke today about this, but the county website does say March 31st. That's where I had gotten it from. So when you sent me your document today, I'm like, oh, something must have changed in the last few hours.
Oops.
That does.
Oh. Dev froze. He's on ice.
He's on ice. Okay.
Yes.
We lost him.
Awesome.
Oh, wait.
Maybe we just wait a couple minutes, and if not, maybe, I don't know, Rachel, did you want to share a little bit, and then hopefully he'll jump back on?
Yeah, sure. I mean, share in terms of like move on to the next question or add more to this question, because
add to this question.
I think this. Add. Yeah, I think I hear the question, and I think it's interesting because him and I had a discussion today about that. The Committee website does say March 31st, and then he shared a document today that said April 30th, which could have been something very recent. I'd say that this is all moving stuff, and because of what's going on, it's quite unprecedented. We see, changes in these orders and revisions on a month-to-month basis. So, and to the extent that I would always rely on the county website. That's where I like to go for information, because it's the county that's, drafting the orders. Try not to just do a Google search. Sometimes they're not updated. Sometimes, it's an opinion of something else, and it doesn't have all of the correct information that I would deem to be reliable. But it does say March 30th, March 31st. I'll also add that, it's the 18th now. So, and there talks about it being extended. So, even though there's that discrepancy, it's very likely to be extended. So don't worry about it. But yeah, Des is back. So here we go.
I can hear you guys saying he's frozen. And I was like, what are they talking about? But, all right. I'm glad I was able to make it back in there. Let's see. So there's another question that has to do with, a landlord who says that they'll renegotiate stuff, but then when there's follow-up, it's not clear how much they're going to be able to provide. And in many cases, the businesses don't have a lot of wiggle room. Any thoughts on, uncommunicative landlords, or, they're maybe in denial too, really?
Yeah, it's unfortunate. I've seen quite a few landlords who just don't respond or don't, respond in good time. And so it just frustrates and just leaves our clients so anxious about what's next. The reality is that absent any rights in the lease, you have to work this out with the landlord, right? And so that's just what it is. I think sometimes landlords too are anxious and they're scared. And the most responsive landlords I've seen are those who are presented with an offer that they want to work with, or that seems realistic, or seems that it would be amicable between the two parties. I think what I've seen when landlords start to ignore or get upset or whatever, it's usually when they're presented with something that really frustrates them. It takes them, beyond what they can afford to provide in terms of relief, and they just sit there and try to, they just sit on it, and they can sit on it because they know that they still have the rights, right? The moratorium will expire. They're still entitled to the money, even though it might be delayed or deferred. And so they do have the upper hand. But from what I've seen, where our tenants have been reasonable, the landlords have been responsive. I think it's a correlation there.
The one thing I'll add, because I've seen it come up over and over again, is the tenant will say, hey, I need help. And the landlord will say, okay, show me your financial information. Show me how much money you're losing, how much money you don't have. And then the tenant doesn't provide that. And they say, no, I want the deal. And the landlord just, but yes, you should share your financial information. They're not going to, if you have $100 million in the bank, they're not going to cut you a deal on a $1,000 a month lease. So you need to work in good faith with them to show that you truly cannot pay, and you won't get anywhere if you can't do that.
Yeah.
And with respect to a landlord who's just non-responsive, not paying the rent usually gets their attention. And if that doesn't get their attention, I don't know what to tell you.
Yeah. Because they'll have to communicate to you if they ultimately sue you, right? They can't just do it blindly. You'll get a notice of that. So, but that's true.
Yeah.
You're on mute, Des, but you're not frozen. You're just on mute.
And I could hear you this time, so that's all good. So in terms of, one question has to do with commercial landlords not having to mitigate damages by releasing the property. Is that typical?
They will. It's a technical legal point. Most landlords will, because it's in their best interests, attempt to release the property, but they don't want to get pinned down. Like if they get an offer for the space that like they're not willing to accept, they don't want. Basically, you can't take them to court and say, no, you should have accepted that offer, and the fact that you didn't means that I get fewer damages. So it's kind of an esoteric. It's a complicated legal point. But in all practicality, your landlord should be out there trying to release the space, and if they're not, then I'm not sure what they're doing, because it's definitely in their best interest to try to find a tenant that's paying rent as soon as possible.
Yeah.
I think, we've talked a little bit about, well, you could be sued. And from just shifting gears to the landlord's perspective, although nothing is a guarantee, that is not a good option for the landlord. It takes years, potentially, and even if and when the landlord wins, they may never be able to collect on their debt. So they are motivated to work with you, and they're motivated to find another tenant. And so that's just something to keep in mind generally.
Yeah, again, there are people involved, and you know, and also strategies about how to do stuff. But
yeah, one thing I want to add there, because you said it before, Des, there are people involved. That's really important. Landlords are like the landlords, but sometimes, you know, most of the times their buildings are financed by a lending institution who also has a say in what they can do and what they can give. You know, there might be, you know, like SNDAs and other types of things that are in play here. And it's not always up to the landlord. Depending on the type of business structure, there may be a board of directors who's really making the decisions and not the person you see or you've signed with. And so, yeah, there definitely could be other parties involved, and that's important to remember.
Or you very likely could be dealing with the property manager who's not the owner of the building.
And has no rights whatsoever.
And you might not know who the owner of the building is. It could just be a company with a generic name, and it's owned by somebody. It'll ultimately be owned by real people, but you don't know those people. And you're dealing with the property manager, and the property manager can only do what the owner will let that property manager do. So something to keep in mind too.
yeah, many factors involved. All right, so it's 5:07. I think that I was told by most people that they could stay until 5:10. I'm inclined to power through and get a couple more questions. Is that okay?
Sure.
All right, great. Thank you very much for being willing to do that. I'm trying to select the ones that seem like they're most widely applicable. If you're speaking to the audience, if your question hasn't been answered, we'll try to follow up subsequently with some additional details. If my property is in a living trust, can the landlord sue me to get that if I close my business because I can't pay the rent? Does that make any sense? Is it business perhaps if my business is in a living trust?
I mean, the named tenant?
It's a little hard for me to tell.
Yeah, I'm not sure.
Yeah, okay.
I mean, a trust is an entity that can be sued and sue. So it's the named, whoever's in the lease as the tenant is the entity that can sue and be sued. And if there's a guarantee, it's who's ever providing the guarantee. They can also sue, be sued. They can't sue, they can be sued.
Okay, great. That's useful. So just to reiterate, the reason why the moratorium moved from March 31st is that the county orders, or the county action had basically referenced the governor's action and had also provided in the event that the governor extended something, that the county would extend it to April 30th. And so when the governor extended the moratorium or the availability to issue a moratorium and said that that could be extended until June, it changed the county's moratorium to April 30th. So a little convoluted, but the key part is to understand that the existing moratorium is now in Santa Clara County through April 30th, but that could be extended at Tuesday's meeting when they make a determination on that. Let me go to the top one more time, see if I can squeeze out a couple more of these. I ran a salon in one mall. We were asked to close our salon in December and January. Can we ask them for a waiver of the rent? And if they deny that, do we have the right not to pay the rent for those months?
Yeah, no, I guess that's just the, like, you know, how the moratoriums have been impacting our tenants, right? December, January, there was another shutdown here in the Bay Area. So all of the salons and in-house dining had to cease, but the landlord isn't obligated to waive your rent for that, right? Like you can try to negotiate with the landlord and say, well, for those months I didn't make any money. Can we reasonably work on this? Can I, you know, that's the negotiation. Can I have an abatement? Can I, whatever you can offer, 50%, 30%, but you don't have a right for an abatement or a waiver of those that rent obligation for those months because you were not able to operate, unless there is something in your lease that provides that type of interruption of services language or abatement language, which is so rare. But absent anything in the lease that says that, it's really up to the landlord to offer or to agree to it.
All right, and that brings us to 5:11. I really want to thank all of the speakers today. You guys have done a tremendous job. Again, this is a complex issue. It isn't just, it's not just the law. It's really about the negotiations. It's about the conversations and the relationships. And you guys have done a great job of being able to prep the attendees on ways to be able to move themselves forward. And suggested that, that may be not the loan you want to take out if you're not going to be able to repay it. So starting the negotiations early, I think is a good strategy. And the folks at SCORE and at Start Small, Think Big can help you with that if you're having trouble getting that rolling. Obviously, the landlords are not always going to be immediately responsive, but as Rachel said, if you go to them with a solution, they may be happy to grab that opportunity rather than try to face, alternatives in the future. So again, thank you guys all for being here. I want to remind the attendees that we will have a survey after this, and we would love to get your input about ways that we could make improvements to our future events. Again, thank you all for being here. I'll give you the big clap because obviously the attendees are not able to do so, but thank you so much for the detailed information you got. Also, thank you for the interpreters and all the work that you've put in to be able to convert this into other languages so that the information is widely available. So again, thank you very much. Have a great evening.
Bye.
Bye.